As always, I'm going to take you through a roundup of the happenings at the ODPP this week, and of course, a quick roundup of the courts as things have been happening this week. So our first case today is it's not even actually a case. It's one of the things that, one of the activities at the ODPP this week. ODPP and other stakeholders destroyed illegally imported pharmaceutical drugs. This happened in Nairobi and it was led by ODPP's Noah Otieno. They participated in the destruction of illegally imported pharmaceutical drugs worth about 32 million at JKIA in Nairobi. So stakeholders and ODP came together and they decided to do this as a show of solidarity to just say they work together. 3 nationals were arrested, 2 Rwandese and 2 Congolese. Nationals were charged with 4 counts of unlawfully importation of the drugs, and they were found guilty and fined 2.8 million or imprisonment of 1 year. The next case we look at is of the boy who murdered his whole family, Warunge. He denied the charges in Nairobi. He was accused of murdering his mother, father, brother, and a nephew, and a worker in Kiambaa on 5th of January 2021. He denied the charges during a virtual court session before Justice Mary Kasango and was remanded in industrial area pending trial, a pre-trial hearing scheduled for 11th May 2021. The next case is about 9 people in court for attempted theft. They tried stealing 300,000 from a city lawyer, George Kithi, Jackson, Fidel, Linda, Akinyi, Virginia, Tabitha. I mean, there were 9 people trying to extort 300,000. They denied the charges and were each released on a bail of 200,000, and the case will be mentioned on April 21st. So imagine 9 people trying to get 300,000, and instead they get to pay bail for 200,000. I mean, it just beats purpose. But it happened in the courts. They say you cannot make these things up in Kenya. The next case is a man charged with conspiracy to defraud. Captain Ondabu Kiage was charged with conspiracy to defraud CIC General insurance of 209,866. The money was for a medical bill for 2 of his dependents. He added them as beneficiaries of the Kenya Police Circle medical scheme with CIC Insurance. He was released on a bail of 100,000, and the case will be mentioned on April 28th. The next case is a man who got 40 years for murder. A charcoal vendor who apparently killed his lover's nephew was handed a 40-year jail term. Julius Odhiambo was found guilty of killing John Ogony and was jailed for 40 years. While giving her verdict, the justice says he butchered and mutilated the body of the deceased. The manner in which he did it means that he's a dangerous person who does not deserve a non-custodial sentence at all. So he went in for 40 years. That's a quick roundup of the cases in the court. It's not everything, but just a quick roundup. And I've also told you what the ODPP has been up to this week. It's about the pharmaceuticals. And I will go straight into our topic this week. We have been discussing murder on social media. You have seen us on Twitter and on Facebook giving some definitions of murder, the concept murder and things and all those things that surround the concept murder. And today we are here to just dive into it and discuss it further, because definitely we were not able to exhaust this topic on social. It's quite wide, it's big, and it's very interesting for everyone. I mean, like we said last week, the things we discuss on this show are things that affect you either directly or indirectly. So it's best you join us on this journey and learn together. Let's learn together. Let's get empowered so that we know what to do when some things face us. Please introduce yourself and tell us what you do at the ODPP.
Okay. Thank you, Anita. My name is Jacqueline Omol. I'm a principal prosecution counsel, currently based at Makadara Law Courts, and I have been in this office since 2014.
Wow. Jackie with a Q.
Yes, with a Q. It's French.
It's French, right? Interesting. Karibu sana. Please introduce yourself.
Yes, good morning, everyone. My name is Alois Kemo. I'm a Senior Assistant Director of Public Prosecutions. I'm based in Mombasa, where I coordinate prosecutions in the coast region generally. Yes. And
how long have you been at the ODPP?
I've been at the ODPP since 1995.
Wow. Yeah. So experience sits here. Experts. We are learning, and we are grateful to have you on the show. Thank you very much for making time for this. I don't know whether I'm right in saying that murder is the most heinous crime known to man. Is it?
It is.
Is it?
It is.
Yeah.
It is the most serious crime and has the harshest penalties in the country.
Yeah. Is it because you can't change the fact that someone is dead?
True.
Oh, okay.
Yes.
So then, what is murder?
Murder.
The legal definition in the most simplest language.
In the simplest language.
Yes.
I would say in the simplest language, murder is killing someone. So murder is ending someone's life. So there's no coming back from that. And murder has been separated according to our law, using the simplest terms.
We'll just get to that, yes. So, I mean, when you talk about murder, and when I was reading about it, and even the definitions we're giving people on social, was that there has to be intent. So maybe just a bit of that, Kemo. Why is criminal intent important in this element?
So
element of murder,
So just as my colleague has said, murder is the unlawful killing of another person by malice aforethought. You have to have the premeditated intention to kill someone. And here sometimes when we're reviewing those files, we look at was it planned, was it conceived earlier before the act was done? We look at what the intention was. Did this person really set out to go and take out the life of an individual? If all those elements are established, then we are satisfied that a charge of murder is disclosed, and we can arraign somebody and charge them with the offense of murder. And I think one other important thing to state is that the state of the mind of the person whom we are charging must be ascertained. Our courts have adopted this practice where an individual must be examined to assess.
At the cost of the state?
Yeah, it's at the cost of the state. Most of them are examined in public government hospitals, where we have a psychiatrist who would assess the mental state of an individual.
So what is looked at? I mean, if they're looking at the mental state.
Sorry?
What do they look for? How do you prove that someone was in the correct or an incorrect mental state?
I think that is that would be best left to the doctor.
To the doctors to respond.
Yeah, but they are the most qualified people
Yeah.
to assess the mental state of a person. They run some tests. They can ask you some questions, and they can come up with a conclusion at the end of it that yes, this person is in the correct mental state, and that he will be fit to plead to a charge. In other offenses, really, because the mental state of an individual when you're handling a criminal case is very important. But there is a provision in the penal code that all of us are presumed to be sane.
Yeah.
It is only in murder cases where the courts have adopted this practice that they must ascertain. Okay. But even in other cases, when an accused person is taken before court, the court will examine an accused person. And if it forms the impression that this person is not mentally sound, it may call for a report on the status of that individual. And if they are ascertained to be mentally unsound, then the court will refer them for treatment. And it is only after treatment that it could be brought back. And then the DPP also will have to determine whether they are really interested, whether we are interested in pursuing the case.
Okay. So, Jackie, you talked about the different, how murder can be broken down.
Yes.
And there's this thing we keep seeing in the news, manslaughter and murder. And so what is murder and what is manslaughter? Are they totally different? And does it mean, like Kemo says, there must be intent, but then there's manslaughter?
Yes.
Yeah.
So how Kemo has put it is, when we look at murder, murder is when there is a premeditation. There's intent to kill. You have planned it, right? And when you go into manslaughter, there is no intent. There's no premeditation to kill someone, right? It happens,
but
someone dies. But you did not intend to end someone's life. So that's the distinction between murder and manslaughter. Yes.
Oh, okay. So people who are convicted of murder are considered less Do you consider them less guilty, less culpable of the crime? I mean, how do you look at manslaughter? How do you distinguish? How do you decide that this is now just murder, this was manslaughter?
We look at the facts. How the facts come to us through the investigations is how we decide whether this is a murder case or if this is a manslaughter case. Like Kemo said, everyone will go through the mental assessment. What we also look for from the doctors is to tell us what was the state of mind of this person when the crime was being committed, right? And also what is his state of mind now so that we can put him on trial. So we expect the doctors to give us such information for us to be able to now ascertain, is this murder or is this manslaughter, as well as the facts.
So there's murder, there's manslaughter. Now what is attempted murder?
Attempted murder is attempting.
But does someone really die?
No, in attempted murder, someone does not die. You will look at the case of Babu. We know that we have before the court now. That's an attempted murder case. The complainant did not pass away, thank God. And so we are charging him with attempted murder.
Oh, okay.
Yes.
So American drama series have really spoiled us. That is something I think a lot of the questions people are asking are based on what we watch on TV.
Yes.
How to get away with murder, those criminal series. So we keep hearing first and second degree murder. Do they apply in our jurisdiction? And is there a third degree? Yeah.
So if you look at the American justice system, they classify their murders with first degree, second degree, third degree. They also have different classifications for manslaughter. They have voluntary and involuntary manslaughter.
Okay.
Yes.
We don't have those.
We don't classify our murder like that. We have murder and we have manslaughter. So in the American justice system, basically, first degree murder, they define it as ending someone's life, killing someone, the unlawful killing of someone.
Okay.
Right?
Yeah.
That's first degree murder. Second degree murder is the unlawful killing of someone during the commission of a felony.
Okay.
So for example, someone comes to your house to rob you. His intention is to rob you of the items in your house, but they come with guns. And during the commission of that robbery, they shoot and kill you.
Oh, like the one that happened in Gong for the KBC?
Yes.
Okay.
Right? So when during the commission of the felony, they kill you, then that's second degree murder classification under the American justice system. In Kenya, we'll still charge you with murder.
Still murder?
Yes.
Oh, okay. Yeah. Interesting. We are really spoiled by this American series. Sometimes you feel like a lawyer when you watch these things and you feel you can represent someone. So we speak about an intentional killing, we speak about murder, manslaughter, but then there's homicide, Kemo. So, and before that, you talked about a felony.
Yes.
So what's a felony?
A felony is an act. I want to make it so simple that everyone would be able to understand. Kemo, maybe you can simplify it.
Hata kwa Kiswahili, felony ni crime.
So I think the term felony refers to generally the most serious offenses.
Okay.
And as opposed to a misdemeanor, misdemeanor is less serious, and there are those offenses that would attract a sentence of up to a maximum of 3 years. So you're looking at anything that would attract a sentence over 3 years. We regard that as a felony.
As a felony.
Yeah. So murder, which we're talking about, attempted murder, all this.
Trust me, I also struggled with the definition of felony.
Yes.
I kept wondering, so what is a felony? But that's clear. Something that takes you to prison for more than 3 years is a felony, right? So now, take us now to homicide. What is homicide?
Homicide is just also another term for killing. And
again, we are spoiled. Because we see crimes, we do injustice, and we see those things there.
Homicide just encompasses the whole.
So homicide is a killing.
The killing. So manslaughter goes into homicide, murder goes into homicide, the infanticide goes into homicide. So it's any type of killing, it's all classified as homicide.
And I know why you're spoiled with this homicide term, because we imagine homicide is a killing of many people at once, you know. Now, not genocide, like you go to like a place, like you see the terrorists do it. So we when you see many bodies on the floor, like that's a homicide, because that's how what TV has taught us. But now you're saying homicide is just killing. If I come
as an investigator to your premises and there's a dead body,
that's a homicide.
So Anita, we have like in the office.
Yes.
We have the homicide division. It just means that it is the division that deals with all those cases that Jackie has talked about.
Okay.
Yeah.
Interesting. You see, you're learning. I mean, even just basic definitions seem so difficult. So then when I was looking at homicide, I saw that there's justifiable and excusable homicides, meaning there's a justifiable killing, right? And an excusable one. What is that even? How do you justify a killing?
Now, the law allows you as a person to protect yourself when you're in danger.
Yes.
Right?
Yeah.
So one of the defenses in a murder or a manslaughter or a homicide case in court is self-defense.
Ah,
right?
yes, yes, yes.
So if I am attacked and I use force to protect myself and the person who was attacking me ends up dying, then that's a justifiable killing, right? Let's say what is very common now in Kenya when we see our police officers.
Just about to bring that in, yes. So when police are stopping a riot, for example, and someone dies, like see, during post-election violence, remember the Baby Pendo case that was so big?
Yes.
Where do you place that?
So police can be exempted from facing charges of either murder or manslaughter because of the force that they use to protect themselves and to protect the public.
Yeah.
But also remember that sometimes their force is too excessive.
Yes. Yeah.
And then they would have to be investigated and then again prosecuted for using too much force.
Yes. Yeah.
Because they've gone through the training and they know this is the amount of force that we should be using on this particular case, right?
Yeah.
But they use excess force. That would put them on the hands of the prosecution and you have to prosecute them.
Yeah. Okay. Because that has really raised a lot of yes, Kemo.
Yeah. So Anita, when talking about the police, I think the National Police Service Act makes those provisions, and it stipulates the circumstances under which an officer may use, for example, a firearm. You know, it is supposed to be proportionate to the offense maybe he's trying to prevent. So if, for example, maybe you want to arrest somebody who is unarmed, I think it would be deemed excessive to use a firearm against such an individual just to effect their arrest, unless there is an imminent threat either to your life or to your security. Then you may be justified. And even then, they should try as much as possible, maybe to maim, to restrain them in a way that they can be able to effect the arrest. So it all depends on the circumstances. You're going to be looking at the facts that have been presented by the investigators. Yes, and determine whether this was a case of excess force used against a citizen or not. But the police they fall among those categories of persons who are allowed to use, because they protect our lives against criminals and even against
and they are partners in the criminal justice system. Yes. But of course, there are those exceptions where you hear maybe there was a riot and the police shot in the air and the bullet landed on someone's son and they died. Where are those ones placed?
Again, it all depends on the circumstances. Typically, you'd ask yourself, if someone was shooting in the air, how come maybe the point of entry of a bullet was maybe right through the chest? If you're shooting in the air, how did that happen? So those are the things that we normally look at in helping us determine whether to hold somebody culpable or not.
Yeah, there's been a lot of hears about excesses done by police when on duty. And I know a lot of people have been asking about the DPP's intervention in these things. What happens? And I know you work with IPOA. So how do you work with IPOA? How do you partner with them too?
So IPOA is that authority that was set up, I think, pursuant to the Constitution, the 2010 Constitution, to oversight. It's a civilian authority that oversights police. And one of their functions is to investigate police excesses. So just like any other investigative agency, whenever they have concluded an investigation, for example, into a shooting where maybe there's been a fatal shooting, they will submit the file to the DPP, who will then review the file and they make a decision whether or not to charge an individual, and with what offense, if any, that that person should be charged with.
So when there's a case against the police, they don't investigate themselves. It is done by
nothing bars them from. I have seen cases where police were involved, and their colleagues investigated them, and they presented very watertight evidence. But I think there were concerns before IPOA came into being that being officers, there was this possibility that they could defend
their bloodlines.
Their bloodlines. So I think that's the reason why we came up with IPOA, to have an independent institution that could investigate those cases very objectively.
Okay.
Yeah.
And Mr. Kemo, can you tell us whether you've had a case where a police officer has been prosecuted to conclude?
Yes. I think the last case I prosecuted, we had a case in Nairobi, when I was still in Nairobi, in 2018, where there was an officer who beat up a person who was in his custody. I think it was in Ruaraka. And that case was investigated by IPOA, and the accused person was convicted and sentenced to death. He received the highest penalty.
Oh.
Yeah.
So there are successes in that.
There are successes in that area, and of course, in you know the Kwale case, where some officers were also convicted.
Yes.
A few years ago. Yeah. So.
And now that you mentioned Coast, is this what did you do with Haki? Is it Haki Africa?
So with Haki Africa, we have a project we do with Haki Africa. Haki Africa is a non-governmental organization that deals with human rights. And the project we have with them came about as a result of a study into the human rights violations that we were experiencing, or the citizens and individuals were experiencing in the coast.
Yeah.
And also issues relating to access to justice to the individuals and communities, again, in the coast. You know, in the coast, there's a very major issue with the land.
Yes.
So the communities out there felt left out. They didn't have ways in which they could have their grievances addressed.
Yeah.
And so the project, the GREAT project, which we have with Haki Africa, basically just brings all the justice actors together. And we seek, the major goal there is to just build trust between the justice actors and the communities. So, for example, we would hold joint trainings as justice actors, discuss some of the challenges, discuss the best practices that we need to adopt to build confidence in the public, in the justice systems that we have. It is only when we do that that the young people, particularly in the coast, will not venture into violent
drugs,
because when people lose trust, when they do not have avenues for resolving their grievances, what they'll do is they'll take the law into their hands.
Yes.
Yeah.
Yes.
If you have a dispute with somebody over land, they would rather pick up a panga and maybe attack you. So that is basically what we are trying to do. And we have seen successes, because more and more we are seeing people volunteering to come to us, because the justice centers that have been opened throughout the coast region. They receive complaints, they refer some of those cases to us. And we have also gone to the communities and talked to them. We have even conducted legal aid clinics where they come, present the problems that they have, and we go back to the office and see how best we could resolve some of those things. And then we also enlighten them on some of the policies that the DPP has put into place.
Yeah.
Diversion, plea bargain that really affect them.
Yeah.
That could really help in seeing them access justice. Yeah.
Okay.
Yeah.
Oh, thanks. So, thanks so much for that. That's very clear. So, Jackie, Not because you're a woman, but because I need you to say something. So there's a case of a 15-year-old girl who procured an abortion.
Yes.
Who is to be charged in such a case? Because abortion is murder, right?
Yes.
And let me not get into the details of So anyway, so what happens to this person? Who is to be charged in such a case? Is it a person who helped her procure the abortion, or is it both? Where do you take this child?
Okay. So that's a tricky situation, right?
Yes, yeah.
Because we have a minor
Yes.
in the equation.
Yeah.
And which means there was possibly also a defilement that
Yes.
happened in the equation. And then we have the person who
Helped
helped
procure.
procure. So there is a charge for the person who has procured an abortion within the law. There is a charge for the person who assisted someone to procure an abortion within the law as well.
Yeah.
But as prosecutors, right, we look at the cases on a case-by-case basis, right?
Yeah, yeah.
So given the circumstances of the minor, and we try not to punish children so
Yes,
much.
that was made clear. Yeah, yeah.
We try not to punish kids. So we would look for a proper way, probably counseling. I think my colleague was here last week.
Yes,
speaking
yes.
about
They are
the
very clear about
Yes.
children. Yeah.
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 So we would try to ensure that the girl is also protected within the law, but not that we are advancing that minors should procure abortion.
Yes.
Right.
Yeah. Okay. So one of the posts you put up last week was that the DPP or the ODP doesn't work in isolation.
Yes.
They are actors in this space.
Yes.
That from the time you get a case, the time you make the decision to charge,
Yes.
there are those things that have to be looked at.
Yes.
So how do you arrive at the decision to charge a murder suspect? And maybe just take us through the process. And maybe actually just take us from the time you hear there's a murder, what happens? Who starts?
Who starts?
Yes.
It depends.
Is it the police?
There is prosecution-led investigations.
Oh, yeah.
Right?
Yeah.
And then there's investigations that are just done by the police.
Yes.
So if there's a murder, the police will definitely go, collect evidence, interview the witnesses,
yeah.
right?
Yeah.
Get the doctor's reports and compile a file and bring to us as the DPP.
Yes.
Then we go through the file and see, are there any loopholes? Are there areas that have not been covered that we need covered? Because now we look at it on the legal side.
Yes.
If I go to court, what does the magistrate or the judge expect of me as a prosecution to bring forth for us to be able to get a conviction in the case? So that's now where we make the decision to prosecute.
Yeah.
Under the decision to prosecute, we look at the evidence and weigh it. Is it enough for us to go to court? Are there areas to be covered? Once the areas are covered, then we go to court. Yes.
Okay. So I also learned again from this show that the decision to charge is the most important decision a prosecutor makes. And it's very important to just know that they're actors, just not you alone, that all of whom play a role in bringing the case to court. You know, people keep complaining that the DP is not doing much, the DP is not doing this, but then there's the police, there's the defense lawyers also doing their work, and then now there's the DPP and the prosecutors.
More and more, we are seeing more actors coming.
Yeah.
It is no longer an issue that is left to the DPP alone. There is the court, of course, before whom we have to arraign someone.
Yeah.
The DPP has a role to play.
And you don't run the courts.
And I don't run the courts.
Yeah.
But as soon as somebody is arraigned before court, the issues of bail come into question.
Yes.
So we are seeing more and more courts relying on pre-bail report. So a probation officer would be required to inquire into the background
Obviously.
or give a social inquiry report on an individual who's applying for bail. In the case of a child, a children officer may be required to do that. And so many other, maybe investigative agencies, there might be a person who maybe needs some form of support. All these are players that get involved once
there's a case going on.
Case that is going on.
Okay. And now even doctors, because you're talking about murder, so the mental assessment report
that has to be done. Yes. So tell me again, Jackie, about inquest. I mean, what is an inquest first of all, and what happens when in a murder case and the inquest has to be done?
Okay, an inquest is an inquiry into the facts of a case. So inquests usually happen when there's a a death or a disappearance that cannot be easily explained by the facts that are available. So it puts us all into like investigative mode, all of us, the magistrates and the judges, the prosecution and the police and the witnesses. So we're trying to piece the puzzle together to see if we can complete the puzzle, right? And see if there is someone to be prosecuted at the end of the inquest, or if the inquest can be closed and said, okay, so this person died and it was not anyone's fault, and that's the end of this, right? So like there was the murder, the murder suicide of the police officers, right? So
which one is this, the most recent one?
The recent one,
Okay.
right? So the officer allegedly shot his wife and then shot himself. So there'd be an inquest in such a
Why do we
case.
say allegedly?
Allegedly, because we have not proven that he is guilty before court.
Okay.
Yeah. So allegedly, yeah. So there would be an inquest in such a matter, just to find out what the complete facts of the case, and then we close the case stating that there will be no one to charge, because in this particular case, the perpetrator is deceased.
Yeah, so there's no one to charge.
Yes.
So an inquest, yes.
So
Kevin.
Anita, so you need to know that where somebody dies, maybe under suspicious circumstances, a case can never just be closed like that. The law requires that it is only a judicial officer who can close
A case.
a case. For that reason, it is mandatory where somebody dies in the custody of the police or in prison that an inquest must be held. Of course, because these are people who are in custody. We must ascertain what really happened while they were in custody. And in the case of what my colleague has just spoken about, where the circumstances under which somebody died are not clear, they are suspicious.
Yeah.
You cannot attribute it to, from what has been presented, to a particular individual. An inquest would normally be held. And in an inquest, they're not trials per se. They are inquisitorial proceedings. You are inquiring into the circumstances in which somebody died. And anybody who has any information about that incident where somebody died would be required to come before court, tender any evidence, or say what they know about a particular case, at the end of which the court is going to make a determination. Either the court is going to close the matter if there is no foul play suspected, or if the court is satisfied that the evidence that has been tendered before it points to certain known person or persons, may direct that further investigations be done. Or if it is very clear, the court may even just direct the DPP to consider instituting appropriate charges against
So who orders for an inquest? Who orders for an inquest?
It is the DPP who orders for an inquest where somebody has died under suspicious circumstances.
And Anita, I don't know if you've ever attended an inquest. It's a public inquiry. So you, as the member of the public,
to ask you, are these actual people who are told to?
The members of the public can come and sit in court, and they're free to ask any questions to the witnesses who are on the dock. So we have a lot of inquests, especially when it comes to accidents, right? Because you find that an accident has occurred, someone has died. We don't know if this driver was the one on the wrong.
And it's very good you mentioned that, because there's a question on vehicular manslaughter. So, I mean, what is vehicular manslaughter? Just as we are winding up on the definitions.
The way we put it in Kenya is we would charge you with causing death by careless driving.
Okay.
Right?
Yeah.
So it's still manslaughter.
Yeah.
Right? So an inquest would come in if there's an accident and someone has died. And we're not sure if it's the driver who's on the wrong or the deceased who's on the wrong. Because you might be drunk and crossing the road and staggering, and there's a car coming, or you jump on the road because you have an intention to kill yourself. Yes, so there'd be an inquest in that, in such a scenario.
But let me ask you, and this is just from a very pedestrian point of view, motorbikes, boda bodas, how many inquests can you for because of how many the accidents we see every day and how careless sometimes they're really around town?
Yeah.
I mean, what happens in such cases? Because there are really many, I believe.
There are many, right? And I, from my experience, even at my station, I'd say most of the accidents that we have from the motorbikes,
Yeah.
usually you find that the driver of the motorbike is charged before court because of the witnesses that we get.
Yeah.
And they say this guy was driving in motorcycle very recklessly, right? But
And they rarely survive, Jackie.
yes.
Yeah, so all those files, if you just wish to know, all those files end up at the DPP's office to determine.
Yes.
Yeah, of course, where somebody, it could be a self-involving accident, it is fatal.
Yeah.
That is a case that would just be closed. But again, we look and determine who was on the wrong.
Okay.
Before we decide.
That's a lot of work. I think we need to do sensitization on border guys. So like, we are on Facebook Live and I believe on YouTube as well. And there are questions that are coming up. Thank you, Faris, for following. Chepchurchir Kimutai, thank you. Gilbert Wanami has asked a question. Thanks, Gilbert, for your question. So when there's a robbery with violence crime and someone dies, which offense is charged, bearing in mind both offenses are capital offenses and attract as a sentence of death? And even before we answer this question, he's brought up another definition. What's a capital offense?
A capital offense is a serious offense where the punishment is death. That's a capital offense, right? And Gilbert, I think if you caught us in the beginning, we said that in our system we do not have the distinction between first degree and the second degree murder, right? Like they do in America. In America, that would be a second degree murder charge, but in Kenya it's murder. It's just murder.
Murder.
Yes.
Okay.
So the question you've asked, somebody dies in the course of a robbery. In the definition of robbery, robbery with violence, either immediately after the robbery, you are going to, before or after, you threaten to use violence or you use violence, or in the course of the robbery, you cause death.
Yeah.
That would still be robbery with violence. So.
And the maximum sentence is death.
And
for robbery
the maximum,
with violence.
yeah. The only difference is that robbery with violence is triable in the lower court.
Okay.
Yeah.
I'm about to ask another pedestrian question.
Yes.
I learned about the Murwatetu case. Does it apply for cases like robbery with violence? Can you claim that you don't want the death sentence because... Can you appeal on those lines?
You don't claim, but the court...
I thought it's pedestrian.
The court has been... looking into it many more courts are using the Muratetu judgment to be able to sentence all the types of crimes that we have in Kenya right now. Because it gives the court the discretion to decide, depending on the facts of the case, what sentence is meted out to an accused person. Yeah.
Okay.
So basically, the simple explanation is that
simple is nice.
Yeah. That you cannot fetter the hands of the court in meting out a sentence.
You have not made it simple at all, Kemu.
You cannot tie the hands. Huwezi funga mikono ya koti ukisema hii ndio hukumu ambayo itatoa. Kwamba sheria inasema mtu akipatikana na makosa ya mauaji ya kukusudia utamhukumu kifo. Hapana. Wanasema ni hiari ya mahakama. Kusema kulingana na ile ushahidi ambao umetolewa kwamba hii kifungu ndio nitatoa.
So do you prosecute in Kiswahili? Do you go to court?
I think I'm prosecuting in Kiswahili a lot more than me.
I do it. I think I want to, and particularly where I work, most people speak Swahili.
Yeah.
So sometimes you lose a lot when you are speaking in English. It is translated. What you have said sometimes get lost before it gets to. So why not just communicate in a language that
is understood by all?
And I think this should be encouraged, because when I started work, the only official language of the court
was English.
But thank goodness it is now Kiswahili and yeah.
A mixture.
Yeah, you can
So
do.
long as the people understand you,
Yeah.
which is the most important
Yeah.
part.
Wow, interesting. I think I'd really suffer if I'm to give a whole statement in Kiswahili, not because I don't know Kiswahili, but because Kiswahili iko na wenyewe kama Kemo hapa.
Ata.
Si ndio? So someone else and is just taking us the next part of our discussion. I want us to discuss the alternative means of justice. Do they happen in murder cases? And I'll just go straight into this question by Michael Mburu. Please explain this issue of bailing out murder suspects, even if it looks as a straightforward case. First of all, is there anything like a straightforward case?
No.
Okay.
Open and shut. Maybe I don't know. I don't know what they mean like a straightforward case. But
Stuliona.
maybe evidence was direct.
And that is again brings it to the study of evidence, and we're going to discuss it later.
Yeah.
If there was evidence, there was tumeona video kwa social, tumeona amemuua. I mean, that's straightforward to us. Is it straightforward to you?
No.
It's not, because if there was a video, there are things we must inquire into. The court would want to know the integrity of that video that we are relying
Yeah.
on. Where did it come from? Who took that video? How was it stored? Between the time it was between the time it was retrieved from wherever, if it was a phone, if it was a CCTV, up to the time it ended up in court, you must account for that. So you know all these things about Photoshop and manipulating of digital material. So the court has to be satisfied, and there are safeguards under Section 78A of the Evidence Act, which must be adhered to. And then finally, a certificate has to be prepared by the person who maybe is retrieving it from the
It's
computer.
a whole process.
Yeah, it's a whole process. We rely on it. All these CCTVs, these cameras you see on our roads these days, there's a lot of data which we have used.
Oh, good.
In cases, yes.
So they actually work.
They work.
They do work, and we have to be very particular about especially our video evidence, right? Because they can easily be manipulated, and you wouldn't even know that it's been manipulated.
Yes.
It's one type of evidence that you can mess around with, and we wouldn't know that you've messed around with it unless there's an expert, right?
Whoa.
So you can see videos all over social media about ile
Cases,
mumeona, sio?
And we're very good at sticking to our straight path.
But the court will want to look at things like, an expert will look like at the resolution of the camera. Was it a wide range camera or not? There are things that was the lighting okay with the camera? Was the camera even cracked or broken? Such things matter in court, right?
Okay.
If you look at the George Floyd case,
Yes.
the girl who took the video that was circulating around the world, she's a 17-year-old girl, right? She was brought to the stand to testify as to what she saw and confirm that she's the one who recorded the video. You see that part?
Yeah.
Then secondly, they brought other people who were at the scene to corroborate what she saw and what she recorded. And then the person who processed this video from the phone to a CD, that process, that's to confirm that it has not been tampered with, has to also come to court and give us a certificate and say, I did this process was done properly with properly working machines, and it was not tampered with. So if we don't have all that before the court, then we might not get a conviction, despite the fact that tumeiona kwa video.
I know.
Then Anita, it is very important for people to know that anybody who takes a video out there, it can be used in evidence.
Yes.
I've done a case where somebody maybe was standing by the road and was taking a video or was taking photographs of an incident as it was happening. And he came and proved to us that they are the ones who took those photographs. We used them in evidence.
Wow.
Yeah.
So
everybody has a role to fight.
But they also have to present themselves before court, because we can't use the forwarded like the one
forwarded many times.
We need the person who made the video.
Okay, now they're talking about evidence. Can you charge for murder when the body is not found?
You can. It has happened in other jurisdictions. I don't know about Kenya. I didn't see even one case where we charged without a body. Mr. Kemo, I'm not sure if you did.
There's a case I think there's a case I've ever come across where I think somebody was attacked in the home, and I think there were 2 people in that home. So when the attack happened, of course they were attacked with a panga. He knew who was attacking. The other person ran away. And when they came back, this other person who had been attacked was not there. The attacker was also not there. But they could see the dragging, that the body had been dragged.
Yeah.
And they were also following the trail of the blood up to the mouth of a river, a crocodile-infested river, actually. And I think there was a shoe or a sandal which was identified to be belonging to the deceased, which was found at the mouth of the river. I mean, you know, in all these things, we normally make inferences. In a case that is wholly dependent on circumstantial evidence, which you're looking at the surrounding circumstances. The issue would be, how can you make a compelling case? And in this case, I think the argument was that, yes, this person must have died because this person saw him being attacked with a panga very viciously. And there were drag marks from the scene of crime up to the mouth of the river. And at the mouth of the river, there was a slipper. So we concluded that that body must have been consumed by the
crocodiles. Oh, okay.
So in such circumstances, but I know in Uganda there's a case where I think that happened without a body also.
Yeah. Okay. So we're talking about alternative means of justice in murder cases, plea bargain, bail, bond. I mean, how do this work? I mean, are there exceptions in the process? I know I think we learned last week you cannot pull a diversion on a murder case, can you?
Not really.
Again, you look at the facts.
Yes.
You're such lawyers.
Yeah, we have to look at the facts. So in the past, there's the case of Mohammed Ado, where it was a murder case, and then there was a withdrawal because the parties had been able to settle out of court. The families came together, discussed, and they were comfortable with this person not going through the court process. And the court in that instance allowed the withdrawal, and the guy was set free. But after that, there has been a bit of reluctance in the court to have
such resolutions,
alternative measures taken outside the court process. With the public is pushed more to, yes, you can agree and settle and forgive, but the court process has to go on. And in such instances, then we would offer the plea bargaining, right? And would plea bargain murder into manslaughter, depending on the fact again, or just murder into murder, but then the court will sentence you differently because you have pleaded guilty, right?
Yeah.
Yes.
Okay.
So my take on it is this, that if you look at the Constitution, Article 11 talks about culture being the foundation of a nation.
Hatupendi kusoma sisi wa Kenya.
Article 11, culture being the foundation of a nation.
Yes.
It goes on to say that the nation shall promote so many things. One of the things it should promote is cultural heritage.
Yes.
And what is cultural heritage? When you're talking about cultural heritage, you are talking about practices that communities have had over time. And in our traditional systems, my ancestors, for example, had ways in which they resolved their disputes.
Yes.
There were murders then. And there were ways in which they resolved those disputes. And by the way, Africans, in very rare circumstances, meted out the death penalty.
Yes.
Because the argument was they do not want to see two families being left without perhaps
their breadwinner
or something like that. In fact, in some communities, you would even have the person accused being forced to take over the family of the deceased, just to care for them. So it was an added responsibility for an individual, of course, along with other penalties. So That is what the Constitution provides, that culture shall be the foundation of our nation.
Yeah.
Then you have Article 159(2), which stipulates that judicial authority, in exercising judicial authority, courts shall be guided by things like alternative justice,
Yeah.
ADR methods, for example, reconciliation, promotion of all those things that are set out there, including the traditional
Methods
justice
of
resolving
conflict,
disputes. So what are we saying? That the Constitution, which is the supreme law of the land, has indeed allowed us to do what? To seek alternative.
Yeah.
And that was our culture. We are Africans. These other things in the penal code, they were brought. So my argument is, yes, it is possible. I think what needs to be done, and we are moving in that direction, is we need to have a policy in place so that all this is done in a structured manner, so that there is going to be consistency. If this is being done in Lamu, in Mbita, the same thing is being done.
There should be guidelines.
There should be guidelines, so that there is uniform. Our cultures differ, but that should be it.
Okay.
And of course, as she said, there are some cases. There are even reported cases where people sat down, communities agreed, cows were paid.
Yes.
And the courts recognized that, yes, these are cases where they did not violate the spirit of the Constitution.
Yeah.
So they were allowed to withdraw those cases, and hopefully, I hope they went and lived in harmony.
Yeah. And I think largely traditional African society was more restorative in how they dealt with such cases.
Yes.
I agree with you because I'm a student of conflict and peace. So thanks, Valerie Ongeti. Valerie has a question. Good morning. I have joined the discussion now. In some jurisdictions, any person charged with murder can enter into plea agreement with the prosecutor or state. But is that the case in Kenya? Again, I think this one is informed by what we watch on TV. Or are there special considerations? And a question has been asked before litigants. Do we have first-degree murder, serious homicide etc. in Kenya, though unwritten? I think we've answered the question on first degree and homicide earlier in the show, but she says she just joined now. So maybe just help her understand, can any person charged with murder enter into a plea agreement? Is it any person?
So, Valerie is my colleague. Good morning, Valerie. In Mombasa.
Okay.
So, yes, a person charged with murder can enter into a plea agreement, but it would depend on the circumstances.
Okay.
The law allows the DPP to enter into a plea agreement with the plea bargain with any person charged with any offense.
Okay.
And it will depend if the circumstances disclose pure murder.
Yeah.
We may not be willing to, because that will not be fair. It will not be just to negotiate.
Yeah.
The only circumstance where we can enter into a negotiation is maybe where we are looking at strengthening the case that we have. So, for example, you have maybe 4 people who are charged with the commission of that offense of murder. And there is 1 or 2 who bear a higher responsibility, the people who really conceived it. And perhaps they got somebody to help in the process of commission of that crime.
Yeah.
We may determine that this person had a lesser responsibility in the commission of the offense, enter into an agreement and agree in exchange for that person testifying against the people who had a higher responsibility.
Yeah.
So you see, we are getting good evidence that will help us nail the people who had a higher responsibility, the people who actually conceived the offense of the taking away of life of another individual. In that circumstance, yes, we may enter into a plea bargain with an individual. In others, depending on the circumstances, the DPP may be willing to negotiate and charge with a lesser offense. And even in the scenario that I've just given, it could be that we will charge because they committed an offense. We could say charge them manslaughter. They would plead guilty. Perhaps the court will urge to mete out a lenient sentence. I've seen sentences ranging from 7 to 8 years.
Yeah.
And in return, that person now comes and testifies against these other individuals. So you can see it's a way in which we help strengthen our cases, because sometimes it becomes very difficult to detect. The evidence you have may not be very strong. So you're looking at how you can strengthen. And when such an opportunity arises, yes, we normally consider it and we can enter into a plea agreement.
Okay.
On those terms.
All right. So there's the question of bail and bond, and this one raises hairs also. When you see there's a case straightforward to us, a person is arrested, and then the next day or 2 days later, he's released on bail and bond. How does that work? Does everybody qualify, or who doesn't qualify for bail?
So, Anita, according to our Constitution, Article 50, everyone who is charged is presumed innocent until proven guilty.
Yeah.
But that's now when the process is finished. So basically, all offenses are bailable. But there are some times that we have to look at whether it is a good idea, simple terms, to give this person bail or bond. But everyone has a right to bail or bond. Doesn't matter the offense they are facing.
Yeah.
So we look at things like, is this person going to be a flight risk? If this person, we release him today and he's on a plane to another country where we can't get him, then we will be praying that bond not to be issued. Even for his own safety, is the community acceptable to him going back? Or would he be killed when he goes back? Yes. So that would be a reason enough not to give someone bail or bond. If you look at interference of witnesses, especially like in sexual offenses, you find that when you're given bail and bond, someone goes and still starts harassing the complainant again. So that would be a reason not to be issued with bail or bond, right?
Yeah.
So those are the reasons that would say we as a prosecution would be praying for the court to look at when giving this person bail and bond. And then the court will decide whether they should get the bail or bond at a higher scale or a lower scale or not at all.
It's the court that decides.
The court decides.
So when you're out on bail or bond, you're not free.
No, you're not free. Your case is proceeding. You're still an accused person.
Because again, from our view, is that person has been set free.
No.
Case he may end
the principle is that everyone is presumed to be innocent until proven guilty. And so I think it comes from the premise that it should not be regarded, custodial, holding somebody in custody pending trial should not be regarded as a punishment. It is not a punishment. Maybe that is the mistake that people make.
We want to see you in jail.
Everybody is innocent, presumed innocent until they are proven guilty. But there are people who, when they are suspected, they start issuing threats to witnesses.
Yes.
They may even issue threats to judicial officers or even to prosecutors, sometimes even to police officers. So in such circumstances, if we can prove that this is what is happening, then we'll plead with the court to restrain that person until the case is determined. Yeah. Those are some of the scenarios, and the scenarios that my colleague has talked about.
Okay. And Anita, that's why we use the word alleged.
Again,
right?
Alleged,
yes. We use alleged because you are presumed innocent.
Okay, that's important to note. Thanks, Gilbert Wanami, for your question. Is it in our law that murder-accused persons must be taken for mental test? We said yes. What happens to an accused person charged with murder, but there was no mental assessment?
So,
have there been cases, maybe before this constitution or maybe way back, that were concluded without the accused going through mental assessment?
So there was a case. I think it's a reported case in my reading, that, of course, you're talking about a mental assessment or a post-mortem report?
Mental assessment.
No. Okay. I think the case I'm talking about is a post-mortem report, where actually the court went ahead and convicted for murder in the absence of a post-mortem report. It had been done, but I think the case was closed before the post-mortem report was produced. In the case of a mental, I don't know whether you have any
I
example.
have not seen any.
So you have to go through mental assessment.
Usually the court is very strict on that.
Yeah.
Yes.
Okay. There's a question here. Just let me get it out. Just give me a sec. So this one is about evidence. I know you depend on evidence to prosecute. So somebody's asking here, what happens if investigations are tampered with or investigations are short? Do you know how we like accusing everyone left, right? And what happens when you actually presented with a case and the evidence has been tampered with? What do you do then?
Well, that puts us as the prosecution in a tough spot,
Yeah.
of course.
Yeah.
Because, we are not investigators. We cannot go to the scene and collect evidence.
Yes.
We rely on the other stakeholders, the other agencies that we work with to bring for us evidence that is in good condition and be able to present it before court, right?
Yes.
So if we get a file where the evidence has been tampered with, would probably be in directing the investigators to find another route around it. Is there, this evidence has been tampered with, but if you find this other kind of evidence, maybe this would be enough for us to go to court. So that would where we would be putting our energy towards.
But a witness maybe the question is, can a witness come and complain to ODPP and say, this was our evidence, what you have is not what we gave? I mean,
that happens.
Yeah.
That happens.
Yeah.
And usually, what I have done sometimes is to recommend to the police leadership in the area where I work that could you assign this case to different officers, perhaps even more senior officers, and let them focus on areas
On
maybe I
getting
could
it
give
right.
okay.
Okay.
So that is possible.
All right. So then the question that I bet everybody wants to know, why do murder cases take long? Why do murder cases take long?
so
What
long?
determines the length of a murder case?
So, Anita, I think you spoke about the statistics.
Yes.
Of how many murder cases we have since January.
There are many.
Yeah. We have 533 murder cases that have been registered and are in before court right now.
Let me just read it actually. So murder 533, manslaughter 131. The first half year of this year, right?
Yes.
Where? Infanticide 15, procuring abortion 14.
Actually, the first quarter.
First quarter. And now that I'm looking at these stats, what is concealing birth? Because I'm seeing 9 cases of concealing birth. What is that?
Concealing birth is when someone is pregnant and does not take care of themselves to go to the hospital or anything, and then they give birth in private with an intention to kill the child.
Oh, I never
You've heard about
imagined.
the children who are collected in a pit like
Yes.
that.
Wow, I've learned something new today, concealing birth. So then there's death incidences, assaults. These are a lot of things. So what makes them take too long?
Well, different things would make a matter take long before court, right? Definitely you can see the amount of cases that are already registered before court.
Yes.
And everyone wants to be heard. So the court diary is basically full. So the court has to arrange itself to ensure that all these 533 cases, everyone has their day in court.
Yeah. And right? COVID happened also.
And COVID happened.
Yeah.
So when COVID happened, many cases were put on hold because we could not have all the judges and magistrates sitting at once.
Yeah.
At some point, the courts were completely closed. So that also affects the speed at which the cases go through. Then we also heard about the transfer of judges and magistrates. When a magistrate transfers to another jurisdiction, then the case has to be heard by a new magistrate who will probably request for typed proceedings to see if they can continue. Yeah. But remember, as an accused person, if a magistrate goes on transfer, you have the right to recall all the witnesses that had previously testified. Yes. So that could also cause a delay before court. Yeah. Then, of course, there's normal things like a magistrate getting sick, a prosecutor getting sick, an accused person getting sick. Things that are out of our control. That could also cause a delay.
And of course, sometimes even witnesses. A witness can also fall sick.
They can fall sick and not be able to. So I think a lot of these things we've discussed, but then we talked about a case of perpetrators not found. What happens in such cases? Like in the case of the KBC editor, the intent was unknown, at least from our perspective. Perpetrators still in our perspectives are unknown. I mean, nobody has been accused or charged with this. What do you tell the family?
Investigations are still ongoing. Our case is never closed. Like my colleague said earlier, like even in an inquest, you can't die and then we say that person died, the case is closed. No, an inquest has to be done and the judicial officer have that declaration put to pen, right?
Yeah.
And then, so what if a perpetrator has not been caught? The investigations are continuing. We expect that our colleagues in the police service are still investigating this matter. So they might not be investigating it in the public eye as we'd want, because we are really following this case.
We are following.
Yes.
Yeah.
But investigations
are still ongoing.
Yes.
Okay.
And the law has a very long arm. It will reach anybody anywhere.
One day, someday.
One day, someday. And you know, and the
There's
good
no
thing, there's no limitation in time.
For
murder.
Yeah.
Oh, okay.
Yes.
Okay, interesting. So there's Bonnie Okemwa. Thank you, Bonnie. He asks, great work, team. The issue of mental assessment in murder cases is a gray area that you need to highlight again. Do we have a legal provision demanding for that process, which is the greatest cause of backlog in most cases, or is it just a matter of procedure?
I think it's a procedural matter. I've not seen any provision that says that an accused must be examined to ascertain their mental status. But it becomes an issue, say in a murder case. So it doesn't harm anybody to have that evidence gathered in the course of investigations of a murder case.
Yeah.
And like when I started work, sometimes it would take so long before it would even come in the course of the trial. But we are seeing more and more courts are insisting that even before the plea is taken, that an accused person must be examined for their mental state to be ascertained. Is it a good thing? Is it a bad thing? I think it's a good thing. It's a good thing.
It's a good thing, yeah.
Because if someone committed an offense out of sickness, then why don't we seek treatment for that person before we go on with the trial? And perhaps if it's a person who needs help, we go into the issue of what sort of help would this person require.
Okay.
So for me, I think it's a good thing that mental state assessment, and it has not posed any problem. We have doctors who are qualified throughout the country who do those assessments on a daily basis. And it would only become a problem if in every case that we take to court, you would require, then I think we would bog down the hospitals.
The system again. Yeah.
And remember, Anita, we said that this is the most heinous crime.
Yes.
Right? And so we have to ensure that the person who we are charging is able to understand the proceedings and comprehend what he has done and the consequences of his actions. Otherwise, it would be a waste of court time and your time to go through all these proceedings
with someone who doesn't understand.
With someone who does not understand.
Yeah, that's interesting. So Eddie asks, on the point of psychiatric assessment, can't we have it executed during investigations prior to plea, as opposed to the current state where it's obtained through a court order?
You see, prior to the 2010 Constitution, we would insist, because we had a lot of time. Sometimes somebody would be detained, and you know that time for capital offenses, they were not eligible to be released on bond.
Yeah.
People would stay in custody. There was something called committal proceedings. So during that time, they were doing investigations, and all these things had to be covered before the file was finally presented to the DPP to make a determination on whether or not to charge. The problem came with the 2010 Constitution, where you arrest somebody today and by the following day, you are supposed to have arraigned him before court within 24 hours. You are aware of that constitutional provision.
Yes.
And so, how much can you do within 24 hours?
Yeah.
Yes, you could record a few statements, you could pick a few things here and there. And you know the constraints under which our police also work. Perhaps, say for example, if talking about where I am, somebody is arrested perhaps in Kaloleni, deep inside in Kaloleni. You want to take him to the nearest hospital. It could take you perhaps a whole day. And this is not something that you can go and do. You have to go with the accused person.
Yeah.
This accused person, you're supposed to present him before court the following day. So I think it became necessary then that there are instances where we have gone to court and asked, can you please give us more time? We have other areas to cover. So you can ask for 10 days. The court in its discretion will give you 3 or 4, because the court might ask, what is it you want to do? And then it will determine that for the things you want to carry out, I'm giving you 4 days. Then you'll have sufficient time to
do it.
To do it. Sometimes you go before court and maybe it is an omission, or maybe they were caught up with time. So the court will insist, can you do this before? Yeah.
Okay. So Eddie also asks, could the panelists talk about maslaha in relation to murder? What's maslaha? Mswahili ni wewe. Wewe Mswahili kwa panel.
I think maslaha is a system that applies in the northeastern part of Kenya.
Yeah.
Where I think it is an alternative dispute resolution mechanism, a traditional practice.
The alternative now. Yeah.
There, where again the elders in the community would meet, the elders from the perpetrator side and from the victim side, and agree on some form of restorative justice, maybe some payment of cows or camels, or even some, in these days, money, or whatever it is they can agree. And then they come back to you and say, in this case, we have settled and would not be willing to proceed. So as a prosecutor, you may insist that you want to proceed with the case, but your case will only proceed when the witnesses are willing to come and testify in court. And that is why I'm saying, as I said earlier, we must recognize, I think we gave ourselves this constitution and we said that the foundation of a nation is culture.
Yes.
And that we must promote cultural heritage. And the same constitution allows us in resolving disputes to be guided by the traditional dispute resolution mechanisms.
Yeah.
So these are things that are there. And if they help people live in the community and in harmony, what is wrong? I think lazima tulegeze.
Let me let's see. But anyway, so maslaha is mostly in the northeastern.
It's in the northeastern. It applies in different formats in different communities.
Yeah.
The western province, they might have their own way in which they do it.
Okay.
Yeah.
Jackie, someone asks here. Christine asks, what entails mens rea? Is that how it's said? Mens rea. In murder cases where accused didn't plan to kill, but circumstances surrounding his actions leading to death accorded the accused time enough to have avoided killing. What does that mean? What's mens rea?
Mens rea is what was your intention? What was your
What is that
state
now?
The mental element.
That's in Latin.
Yes.
Okay.
So what was your state of mind? What was your intention? Right? So I didn't get the last part of her question, but it seems like she's putting together the manslaughter and the murder.
Yes.
So if you had no intention to kill, remember we are in manslaughter.
Yes.
But if you had the intention to kill, we're on the murder side.
Yes. Okay. All right. So kindly bring out the specific, thanks Mary for the question. Kindly bring out the specific elements of murder and the evidence required and probably the new jurisprudence on sentencing. We're just going to speak about sentencing right now, and maybe that would give just a quick summary of sentencing in murder. What is a maximum for manslaughter? What's a maximum for murder? And then what does it mean to go for life?
So when you talk about sentencing, the sentence meted for murder, as per our constitution, as per our laws, is death, right? But remember, in Kenya, we have not actually hanged anyone. Our system was hanging. We've not hanged anyone since 1987.
Oh,
yes. But we still have people who have been sentenced to death.
And most of a lifetime.
And most of the time you find that when we are having celebrations on either Madaraka Day,
people are set free.
They're not set free, but their death sentence is commuted to life. Yes. And life is the maximum sentence for manslaughter.
Okay.
So that's the maximum. Meaning it can start from a day to life.
someone was sentenced to a day. Remember the lady in Siaya?
Yes.
And it was quite controversial. Some celebrated, some complained, you know. I don't want to ask about your personal opinion on that. So someone asks again, why are murder cases only filed and heard in the High Court? Why not decentralized to the lower courts? Thank you, Akio, for the question.
Is there any reason? I do not, other than the fact that it is maybe the most serious offense. I think we tend to focus on other offenses and think they are very serious, but I think it all emanates from the sanctity of life. That life is so precious that it should not be taken. And therefore, when you take somebody's life, I think it was deemed that this is something so serious that it should be tried by the highest court, a higher court.
Oh, okay.
But remember, manslaughter is also tried in the lower court, causing death by dangerous driving in the lower court, infanticide, concealing birth.
Yeah.
We tried those in the lower court.
Okay.
But murder in the high court, and remember, premeditation, you had planned to kill. So I think that gives the higher court the power now to take it over.
All right. It's good you mentioned infanticide because Jacinta asks, can you discuss infanticide? At least today we've learned about concealing birth. So what is infanticide?
Killing of an infant.
Just killing of an infant.
Yes.
Yeah.
Not about 12 months.
Yes.
Yes. And then there's the issue of postpartum. Now the mental assessment is done again.
Yes.
So if you're found to have been depressed at that time, do you still get into the maximum for this, or
You see,
I mean, or it's just
right now is when we are starting to become sensitive to issues like postpartum depression in our country.
Yeah.
Remember, we are still very African and cultural.
Yes.
And where things like mental health was not taken with enough seriousness.
Yeah.
But now that we have our mental health awareness going on, we as prosecutors are also aware of issues such as postpartum depression. And we would also be requesting that the doctors do evaluation of our suspect and see what was her state of mind.
Yeah.
And then there's other avenues that we can take, such as counseling or putting the person on probation.
Yeah.
And if not at all, then even if they're serving a sentence, they're still getting the help
the
that
help
they
they
require.
deserve?
Yes.
All right. Thanks, Gitonga, for the question. How about the issue of availability of doctors for submit post-mortem reports that leads to delays or acquittals of accused persons, where the case was strong against the accused? Is there anything that can be done to have post-mortem reports adopted without the availability of doctors? Are there remedies to prevent miscarriage of justice?
There are instances
Yeah.
where a doctor maybe, because doctors, just like public servants like us, are transferred.
Yes.
So a doctor who was working with me in Malindi could have been transferred to work in Homa Bay.
Yeah.
And procuring the attendance of that doctor can take so much time.
Yeah.
Doctors are also very busy.
Yeah.
So the law permits us to call a colleague of theirs to come and testify on their behalf, provided they are familiar with that doctor, they are familiar with their handwritings. They'll come and say, I've worked with him, we are colleagues for such a long time, I know his handwriting, I can identify his signature, and I attest that this is the signature of that doctor. So, and the defense usually does not object. In certain instances, where you place your predicament even to the defense, they sometimes concede to even an investigation officer producing a post-mortem. That is in instances where it is very clear, or there are no technical terminologies that are used, or they are not really challenging the cause of death. But where they are going to be challenging the cause of death, then it is very important that somebody with a technical knowledge in the area of medicine or that area comes and testifies before court.
I think, Mr. Kemo, you should also mention that we have few government doctors to cater to the population that we have in the country. To be honest, there are few. They are being pulled right, left, and center within the counties. So that does cause a delay. But I think so far we have been doing the best that we can with what we have.
Okay.
Yes.
All right. All right, thanks, Agatha Simoto, for following the discussions. As we wind up, maybe there's this case that I think everyone wants to know why, if a family can withdraw a case against the accused person, and I think that is covered under what you discussed, like in the alternative ways of just attending to these cases. Then someone asks, what if witnesses refuse to attend court?
Now, where a witness refuses to attend court, we can compel their attendance, and there's a procedure. First, the police would bond them using their normal procedure of bonding. They have forms that they use to bond witnesses. So on an appointed date, if the witness fails to attend court, I would maybe request for an adjournment to give them a chance, because maybe there was no explanation. If that persists, I would ask the court to give me a summons. Now, this is a summons that is issued by the court itself, requiring that a person attends court for the purposes of, giving evidence. So this has to be served by a police officer or by a person that is appointed by the court to serve. If, again, a person fails to heed the summonses of the court, the prosecutor is going to be constrained to apply for a warrant of arrest. So a warrant will be issued requiring that person, a police officer, to effect the arrest of that person and produce them in court. So that is the way in which we can enforce the procurement of a witness. It is not a route that any prosecutor
wants to take,
because you are relying, and we should be working together.
Yeah.
Maybe it signifies something, either a witness has been compromised, or maybe they have been intimidated, but we normally urge them to come out and say what it is they are going through, so that we see what sort of interventions we can make, so that justice is served at the end of the day.
And Anita, just as Mr. Kemo said, it's not a route that as prosecutors would actually want to take. You can imagine if you have a rape case, and your complainant is the one not coming to court, and then you're issuing warrants of arrest against this complainant who already has gone through the most traumatic time of their lives. You don't know how they're dealing emotionally. Don't know if that's the reason, because they've not healed, they're not ready to talk about it. And there you are insisting that they come to court and tell people about what happened when they were raped. So at some point you choose not to go through the route that Mr. Kemo has decided. And you withdraw the case under Section 27A, which still allows us at a later stage, when she is ready,
then you can
revive the case.
Yes. Okay, so we are winding up, and maybe one final question is, how does a public follow up on updates of murder cases, especially the ones that are of interest to the public? Where do we follow up?
The public generally, or the victims?
Generally, yes. No, the public.
The public.
We want to know where the case is at. Where is this case? Why is it told?
I can see one thing on that too, and you've done an update today. So on public forums you can get an update, but remember, the court is an open court, right?
Yes.
So if you know that a case you're interested in is in court on this particular day, you might as well just go to court and listen. Because it's an open court. You will not be thrown out. Yes. If it's an open court, you can go and listen and get to know what is happening, or you can get it through the media. And I think our office has done a very good job at always updating the public on where our cases.
So there is also maybe what the public also needs to know. If any of those they're not getting that information, we have a complaints and compliments division where they can challenge any inquiry about any matter, and there's always somebody who will respond to that question. Sometimes it is not possible to know all the prosecutors or the prosecutor who is handling, but the prosecutors are also available to give that information to you, if at all you need it, particularly to the victims, who we really feel obligated to, because we like informing them from time to time about the progress of their cases.
Okay. I think it is important to just wind up saying that the DPP is an independent office, the ODP is an independent office, not guided by any political office. It operates independently. So sometimes when you see people complaining about delays and cases have gone under because of political interest, then it's really not true. It's the process that is taking place at that time. So I'd like to thank everyone who has been with us on this discussion today on Facebook, on YouTube, and on Twitter. We have enjoyed the engagement. We will continue to engage with you on the platforms. There are teams who are still on standby who are going to respond to any question you have. The videos will be up on Facebook again and on YouTube. You can watch again and again if you want to clarify something. We acknowledge you today. We acknowledge your input. And of course, we want to say asante and thank you for staying tuned. We wish you a good weekend ahead and, of course, a blessed week starting Monday. Join us next week for our next topic. And, of course, like our page on Facebook, subscribe to YouTube, and follow us on Twitter. Asante sana. Yeah.